I'm Amy Goodman. We're on the road in San Francisco. The Obama administration released 4 lightly redacted memos Thursday from the Bush-era Justice Department that approved and provided the legal basis for the brutal interrogation techniques used by the CIA against terrorism suspects. President Obama issued a statement calling for reflection, not retribution, and reassured CIA officials that they need not fear prosecution. The so-called torture memos from the Bush administration's Office of Legal Counsel were released as part of a lawsuit and Freedom of Information request filed by the ACLU. 3 of the memos were authored by Stephen Bradbury in 2005, then a lawyer in the Office of Legal Counsel, and 1 in 2002 by then head of the office, Jay Bybee. The memos dispassionately describe the use of tactics such as waterboarding, holding prisoners in small, dark boxes, exploiting prisoners' fears of insects, forced nudity, and shackling and depriving them of sleep for as many as 11 days. They also include extensive legal arguments as to why these tactics do not amount to torture under U.S. and international law. While President Obama said he will not pursue prosecutions of CIA employees involved in special interrogations, he did not explicitly address the question of prosecuting the minds behind the memos, the former Justice Department lawyers who authored the memos. But a Spanish court could prosecute 6 prominent lawyers from the previous administration, including former Assistant Attorney General Jay Bybee, the author of the 2002 memo. I'm joined now by attorney and writer Scott Horton from Washington, D.C. He's been closely following the efforts to release these memos, as well as the Spanish case against the so-called Bush 6. We welcome you to Democracy Now! Scott, let's begin with the release of the memos and President Obama saying he will not prosecute. Talk about the significance.
Well, I think an important positive decision from President Obama to release them. We know that there was a struggle. We know that senior figures in the CIA waged what Michael Isikoff called a holy war to block their release. President Obama personally was involved in the final call. He made that call in favor of their release. The redactions were very, very modest. The names of some doctors and psychologists and CIA agents were blacked out. That's standard procedure, no surprise there. Even the ACLU, I think, was happy to do that. And by the way, we can pretty clearly identify exactly who all those people are, so it wasn't terribly effective either. The surprising thing was, of course, the statement that was released alongside of it, that there would be no prosecution of CIA agents who relied on these memos in performing their duties. And I'd say that outcome, most people who've studied this don't expect that there ever would be such prosecutions, certainly not of ground-level people at either the CIA or the Department of Defense. But there's some very serious issues about how this is raised, in particular because this amnesty, and that's effectively what it is being granted before an investigation of all the facts has been completed. And I think in terms of proper process, it would be appropriate to lay down the facts, to establish them, and then make some sort of decision about amnesty. And second point is we see everything presented in terms of the OLC memoranda and reliance on these memoranda. Well, there's a very important report still being held at the Justice Department dealing with how these memos came to be crafted and released and the ethics of what went on there. I'm told it's devastating, and I think that's going to put a torpedo in the side of this legal argument. But even aside from that, there's a very strange factual issue here. President Obama says that we shouldn't prosecute them because they relied on these memos, but a factual review is going to show that the CIA was using these techniques from April 2002, and these memos were commissioned and written, the first of them, in August 2002. So it's quite clear, in fact, that CIA agents were out in the field doing these things not relying on these memos, not with the memos not even being in contemplation at that time. So this argument is a fallacy. What's really going on here, the CIA agents were acting in reliance on directives that came from the White House, from the National Security Council, that go all the way up the ladder to Vice President Cheney and President Bush. And I think President Obama is concerned about that linkage and that issue, and he wants to blur the picture a little bit.
Scott Horton, what did you find most shocking about these memos?
Well, the clinical detail of the discussion of the torture techniques is just astonishing. I think the bugs in the box instance that you cited, which we really hadn't heard anything before, the discussion of waterboarding. But just back up and put some perspective on this. These are techniques that federal prosecutors previously charged as crimes. Moreover, in prosecutions that occurred at the end of World War II, American federal prosecutors sought the death penalty, sought capital punishment for people who did these things. And now we see a man who is a federal judge sitting in San Francisco writing a memo saying, wink, nod, fine with me, just go right ahead and do it. It's just astonishing, and I think also astonishing that that individual in particular can sit as a federal judge today when the world knows that these memos have been crafted, and in fact, when he's the subject of a pending criminal proceeding in Spain.
Let me read from the document. This is the Bybee memo. It says, in addition to using the confinement boxes alone, you also would like to introduce an insect into one of the boxes with Zubaydah. As we understand it, you plan to inform Zubaydah that you're going to place a stinging insect into the box, but you'll actually place a harmless insect in the box, such as a caterpillar. If you do so to ensure you're outside the Predicate Act requirement, you must inform him the insects will not have a sting that would produce death or severe pain. If, however, you were to place the insect in the box without informing him that you're doing so, then in order to not commit a Predicate Act, you should not affirmatively lead him to believe that any insect is present which has a sting that could produce severe pain or suffering or even cause his death. So long as you take either of the approaches we've described, the insect's placement in the box would not constitute a threat of severe physical pain or suffering to a reasonable person in his position. An individual placed in a box, even an individual with a fear of insects, would not reasonably feel threatened with severe physical pain or suffering if a caterpillar was placed in the box. Scott Horton, your response.
Well, we're seeing the realization of two famous pieces of literature, aren't we? George Orwell's 1984 with the rat. Remember, the rat was selected because after psychoanalysis of the subject revealed that he had a fear of rats. So this was being used to terrorize, quite literally, the individual, as well as Terry Gilliam's filming of Brazil, where we know, again, study of fear was used to drive, to craft special techniques. And that's the predicate paragraphs prior to the ones you just read suggest that with respect to this prisoner, the diagnosis of psychiatrists and psychologists who had studied this case was that he had an irrational fear of insects. So let's use this fear to unhinge him. So the other thing I think we should note going back here is this shows the central role played by healthcare professionals and the crafting and implementation of this entire process. It's clear from reading these memoranda that doctors and psychologists are present at every stage along the way, supervising what's going on, but also suggesting and refining the techniques to make them more terrible.
You know, Scott Horton headed to Spokane. We'll be broadcasting from Spokane, Washington on Tuesday, where Mitchell Jessen Associates is. Can you talk more about psychology?